I want to maybe tell you a little bit about why is labor law important. In human resources, our job is to be a consultant to management and to employees on how to do good business as people. One of the ways that we can be a good consultant is to let people know where the landmines are. And the landmines in this case are the labor laws that they might run afoul of. So why is this important? Very good. We are at a place where we can have a visual. Okay, so there is a federal government agency, the EEOC, who is in charge of keeping employers honest on discrimination laws. We're going to talk about those in a minute. But last year, in the last year that we have data for, they had just shy of 100,000 cases and brought in $1 million a day in fines for employers for violations. $1 million a day, it's a lot of money. The kinds of things, the kinds of claims that people brought in, I want you to kind of remember these, not in order, but you might want to remember some of them. Retaliation is number one. Remember that. Then comes race, sex, disability, and age. Okay, so we're going to talk about that when we get talking about disability, or I mean discrimination, but I want you to kind of keep that in mind. Here's another thing. So there's the administrative route that you can punish employers for violating these laws, but there's also the legal route, lawsuits. So these are lawsuits that were filed against some pretty well-known companies, and you can read through these when you have your thing up. But I want to point out some of the amounts. $100 million. Starbucks. How many have had a Starbucks in the last 2 weeks? Okay, yeah. Starbucks, well known. They were improperly paying tips to supervisors. We'll talk about that. $100 million. And how many of you, if you were in a management role, would feel comfortable taking the check for $100 million into your CEO and asking your CEO to sign a $100 million check to give to a group of plaintiffs? Yeah, they wouldn't like that. You wouldn't like to answer the question about how did we get here and why do you think you're competent in your job? So $20 million, all sorts. Yeah, there's just lots in here. There is one of my favorites. I don't know the name of the law firm, but it was a big national law firm back in Washington, D.C. So it's a law firm. Yeah, they got hit with $27.5 million verdict for having mandatory retirement ages. And we're going to talk about that. It's a law firm. You'd think they would know. Okay. All right, we're going to start out with my own version of a pop quiz. This one's not being collected and it's not being scored. And we're just going to do it by raise of hands. After you're reading, tell me which of these items are mandated by law under the Fair Labor Standards Act. Okay? The first one, overtime pay of 1.5 times the normal hourly rate for hours worked over 40 hours per work week. How many think that's a law? Okay. A 20-minute lunch break for every 6 hours of continuous work. Okay. Pay of 1.5 times the normal hourly rate for holidays worked. Okay. Comp time for exempt employees who work more than 40 hours in a work week. All right. A minimum wage for all employees. Raise your hand. Good, good. And letting employees work voluntarily off the clock. Okay. Okay. All right. So so this one is a law. Overtime pay, 1.5 times the hourly rate for working more than 40 hours in a work week. Lunch break, I'm sorry. The mandatory lunch breaks are not required by law. Holiday pay is not required by law. Comp time is strictly forbidden. A minimum wage is the law, and it's definitely the law forbidding you from letting people work off the clock. If employees are working, they need to be paid. Okay? So you can keep track of how well you did on that, and then we'll talk a little bit about the Fair Labor Standards Act. This law regulates overtime pay, child labor, and establishes a minimum wage, and mandates specific record keeping. So the overtime is 1.5 times the regular rate for working more than 40 hours in a work week. It restricts the hours and conditions of employment for minors, and it's kind of graduated. You can't employ anyone under age 14. From age 14 to 16, they have very strict rules about the hours of days and the kind of work that can be done. No hazardous work, and they are very specific about what can and can't be done. There are exemptions for things like family-owned businesses, like farms. So yes, you can work your farm labor, your children on the farm at very young ages in very dangerous places, and they can't touch you about this. I should give that caveat for all the things we're going to talk about. I'm going to tell you what the basic part of the law says, but each one of these laws has exemptions. They have things that are carved out for specific special pay group or special industries and things. For example, the Fair Labor Standards Act has some special carve-outs for beekeepers. Yeah, the beekeeping industry, I don't know. So I'm just going to tell you the kind of the basics, and there are more things to be learned in a longer class. The minimum wage. So what is the minimum wage? That was on your quiz today. Be brave. $7.25. $7.25 wins. I know, sucks. Now you know you missed that one on the test. Okay. And how many of you have been following all the debate for people saying that we need to change the minimum wage, right? That's been a lot in the news lately. Okay, mandate specific record keeping. This on the second slide on the lawsuit side, I think we had one on Disneyland. Disneyland was fined several $1 million for improper record keeping, not keeping accurate time records for their employees. It's crossing the T's, dotting the I's. They didn't do that, and so there were some fines to be paid. The Fair Labor Standards Act applies to anyone who employs 2 or more people. Okay? Again, there are some exceptions to that, like your family and things like that. But if you're employing 2 or more people, you need to comply with this. And it assumes that you're going to pay overtime to any of those employees unless they have a specific exemption that's written into the law. Those exemptions are, there are 6 of them. There's the executive exemption, which is not as highfalutin as it might sound. It's really anyone who has hire and fire authority over other people in your company. So a supervisor at ARUP, I don't know about other companies, but at ARUP, supervisors can hire and fire, and they control pay. So a supervisor would fit under the executive exemption. The administrative exemption is a little harder. It's It's not an administrative assistant. It's really a person in your company who has the authority to work, to sign contracts and to act in the stead of one of the executives of the company. Very rarely used as far as in my world of human resources, because I'm a pretty conservative guy. Professional exemption, ironically, medical technologist is written into the Act as an example of a professional, one of the professions. There are two kinds of professions, learned professions and the artistic professions. And the learned professions are the ones where the med techs fall. That requires a lengthy regimen of education, and you need to apply the stuff learned in that education to making everyday decisions and using your discretion and judgment to make decisions. Other examples would be lawyers, doctors, nurses, etc. Okay? Outside sales is what it says. These people are not in your business, your place of business. They are outside selling to other people. Computer related is not anyone who works on a computer. Is there anyone who does not work on a computer for their job? Yeah, don't raise your hand, but everyone works on a computer now. The computer related exemption has to do with people who are either doing development, like programmers, or testing. There might be some system administration people who might fall under the computer-related exemption. And then highly compensated, anyone who's not doing manual labor and is being paid more than $100,000 a year can be exempt from overtime. So a lot of us would sign up for that one, okay? All right. So if you have people that you want to be exempt, you must pay them on a salary basis. A salary basis means that their pay does not fluctuate based on how many hours they work. If you do that, then they lose the exemption. There was a very high-profile case here in Utah at Thiokol. They had rocket scientists, very easily would fit into the professional exemption, rocket scientists who the company was paying a salary, but they were deducting from the salary if the scientist had a doctor's appointment. They would deduct pay if they left early for the day to go to the doctor's appointment. So they were, in essence, treating this person as an hourly employee, and therefore they lost the exemption, and they had to pay 2 years worth of overtime to everyone in the category, and then there were big fines to pay on top of that. So it was pretty expensive for them. And then how many of you have seen your job description? Most of you have seen your job description. Human resources departments in most companies will do job descriptions because these are the things that help document whether someone fits into one of these exemptions. They also have other uses that we'll talk about as we go along. Okay. All right, any questions about the Fair Labor Standards Act, FLSA? Okay. We'll march ahead into discrimination laws. There are several that we're going to talk about today. There are some that we're only going to touch on briefly, some that we're going to go into more depth. One of those that we're going to go into more depth with is the Civil Rights Act of 1964. This is the mother of all discrimination laws. And all the ones that have come after that are kind of patterned after it, so we'll spend a little bit of time here. So can anyone tell me what's happening in the United States in 1964, the early 1960s? Civil rights. Thank you very much. You guys have been doing your studying. The civil rights movement was happening. And there was another thing that was happening that doesn't get as much historical press because it was a failed venture, and it was called the Equal Rights Amendment. It was trying to get equal rights for women in the workplace and housing. We'll talk about how the two of these come together in just a minute. But this is what Martin Luther King was fighting for. When this law finally gets to the House and Senate for debate, it gets amended 2 times. So the original bill that came to the floor protected a person's race, the color of their skin, and their national origin. These are all things that Martin Luther King's working for. It gets amended twice. The First Amendment is not very controversial. They added religion as a category that could not be discriminated against, okay, in the workplace, housing, and all the other places where the Civil Rights Act was going to work. The Second Amendment, though, was a poison pill that was added, trying to kill the bill. Now, think about it. Who would want to kill legislation that would grant equal protection to blacks in society? Pardon? People who are white and live particularly in the southern states of the United States, yes. The South. The Southern senators wanted to kill this bill because the South had a culture that was built around discriminating against blacks, and they were loath to get rid of that. And so they added this Second Amendment, and the Second Amendment that they added to this bill was sex. The reason they added sex as a bill goes back to that Equal Rights Amendment movement that was going on at the time. That was very unpopular in the states. Most people didn't like it. And they were hoping, the senators were hoping that by adding sex as a protected category, the other senators wouldn't be able to vote for the bill and the bill would die. And so there would be no law. But their gambit failed, so sex also became a protected category, which ironically meant that the people in the Equal Rights Amendment got their way too. So they were able to get their protections by that gambit. Okay? So that's a little bit about background.